Here at Scott Legal, we know the ins and outs of immigration law. We are here to help you with issues involving removal or deportation from the United States. Turn to us for all your immigration needs. A removal proceeding, also known as a deportation proceeding, is a civil immigration process where an individual who is not a citizen of the United States is subject to being deported or removed from the United States by order of an immigration judge. A non-citizen can be removed if they are present in the United States without status, or, if they are present in the United States with status, for violating a term of their immigration status. A removal proceeding is commenced after an immigration agent has identified a violation committed by the non-citizen. Immigration agents include Immigration Customs Enforcement Officers, also known as ICE officers, who typically identify and detain non-citizens present within the United States. Immigration agents also include Customs and Border Protection Officers, who are also known as CBP officers. CBP officers detain non-citizens attempting to enter the United States, or non-citizens who are encountered near a United States border. Once an immigration agent has identified and detained an undocumented individual, or a non-citizen who has committed an immigration violation, the agent formally commences the removal court process. To do so, the immigration agent issues a document called a Notice to Appear, or NTA. The NTA is served on the non-citizen and then filed with the immigration court. The formal name of the immigration court is the Executive Office for Immigration Review, or EOIR. The NTA serves to inform the non-citizen of the nature of the proceedings, the alleged grounds for removal, the person's right to hire an attorney, at their personal expense, and the consequences of failing to appear at scheduled hearings before the immigration court. Once removal proceedings have been commenced, the first issue that the non-citizen must navigate is whether they will be released from custody or detained. Whether a non-citizen is detained or released from custody is determined first, by the immigration agent commencing the process. Then, if the agent decides to keep the non-citizen detained, an immigration judge will make a determination. Release of the non-citizen is dependent on whether the immigration agent or judge believes that the non-citizen, if released, would be a flight risk or a danger to the community. This determination is based on a review of the violation the non-citizen committed, their criminal history, their time spent in the United States without violating a criminal or immigration law, their work history, and their family ties in the United States. Also note that there are some cases where certain violations require that the non-citizen be detained throughout the process. In most cases, the non-citizen will be released once they guarantee their appearance at future hearings. They do so by paying a specific amount of money, which will be returned when the immigration process is complete. This is known as an immigration bond. The amount of time required for the removal process will depend, in part, on the court's schedule. It will also depend on whether the non-citizen is released or detained. Cases involving detained non-citizens have a higher priority than cases in which the non-citizen is not detained. In cases involving a detained non-citizen, the court makes an effort to complete the case within a few months. Cases in which the non-citizen is released from custody may take approximately 1 year or longer to complete. Again, this depends on the court's availability. During the process, the non-citizen will either challenge the charge of removability, or admit to the charge. In the event that the non-citizen's challenge to the NTA is successful, the charges will be terminated, and the non-citizen will be allowed to continue to stay in the United States. If the immigration judge finds that the non-citizen is removable, and sustains the charge in the NTA, the judge will then ask the non-citizen whether they plan to apply for relief from removal. If granted, relief from removal would stop the removal of the non-citizen. The immigration judge can decide to terminate the removal process, grant relief from removal, or order removal of the non-citizen. The immigration judge's decision can be appealed to a higher court, which is known as the Board of Immigration Appeals. A decision by the Board of Immigration Appeals can also be appealed. This appeal would be decided by a U.S. Court of Appeals. The U.S. Court of Appeals can sustain the Board of Immigration Appeals' decision, overturn it, or send the case back to the lower court, which is called remand. If the case is remanded, the Court of Appeals would give instructions to the lower court to either correct the analysis, or to issue a final order granting relief from removal. If the non-citizen does not win their case, they will either be removed from the United States or, if the non-citizen qualifies, they must voluntarily depart from the United States by a certain date. If the non-citizen wins their case, they will be allowed to remain in the United States. They may be given the immigration status they had before. Or, they may be granted protection from removal or legal permanent resident status, which allows them to live and work indefinitely in the United States. A detailed discussion explaining the removal process, including ways to challenge a removal charge, and forms of relief available to stop a potential removal, can be viewed by following the link on the screen. We are here to help. You can reach us by calling 212-223-2964 or emailing us. We look forward to hearing from you. You can set up a consultation by clicking on the link below, where you can pick a date and time that is convenient for you.